So many thoughts and feelings out there
Absolutely.
today. So we wanted to give you more perspective on today's ruling because there is still so much up in the air.
And we are joined by constitutional law attorney John Runft. John, you have nearly 50 years experience. Thanks so much for joining us this evening. A momentous day for a lot of people. We just heard Brian Fisher say that the governor should continue to fight this. If you were the governor's lawyer, how would you do that, if at all?
First thing I would do would be to comply with the court's order. I think the court has ruled. It's a constitutional ruling. I believe that's the end of the road on that. Now, if they find other ways to go administratively as to how to perhaps proceed, that's different. I mean, there's always room, perhaps, for some sort of administrative handling of something like this, but this ruling is pretty direct. I think this is the end of the road, frankly, for this ban on any kind of gay marriage. The Ninth Circuit Court of Appeals was very clear that the rationale was an irrational rationale. It was a rationale that was not based on reason nor history, nor on fact. So I think it's. I noticed the ruling today said the mandate shall issue forthwith. And that
doesn't that mean immediately? Like, well, licenses should be issued tomorrow morning, 8 a.m.?
I see Deborah Ferguson, the attorney for the plaintiffs over here. But
we'll be talking with her in a bit.
The word shall portends the future, shall issue. And you go back to on page 91 of the previous ruling, the court said the mandate will issue 7 days after the expiration of the time. So in that sense, they were speaking about 7 days after. Now they say shall issue forthwith. Forthwith would mean sometime in the future, like 5 minutes, 10 minutes.
So semantics are back to the 7 days?
Well, normally what court order, as Deborah and I both know, court order is the court orders are herewith orders, the order herewith. There is a sense of the future. Shall issue forthwith. Shall issue 7 days. There's a sense either way of some future import, but not very long. And if I were the good governor, I would say, let's get on with it, get these people before the clerk of the court and get them married. I mean, it's over.
John, the Ninth Circuit could have been clearer, and it wasn't. Why wasn't it?
I never second guess what judges write.
That said like a good attorney.
Well, really, in my view, I'll be frank, the order should have been, we herewith order the mandate to be effective immediately. Herewith effective immediately. That would satisfy everything. But in light of the fact they talked about 7 days and then now shall forthwith, they're still in a way. If that is what Attorney General Watson is looking at to give himself a few more minutes of time, fine. But in any event, the time is very, very short.
Well, what about the U.S. Supreme Court? Obviously, they issued yesterday basically a ruling saying that they're not going to rule on these other states' gay marriage bans, effectively putting gay marriage legally into 11 more states. Is Idaho going to try and move this up the ladder? Are we going to see ourselves at the U.S. Supreme Court?
I would assume, the way things are going, that there's a high likelihood that Idaho may apply for an order for cert. They may apply for a writ of certification. That is an appeal to the Supreme Court. Yeah. But I don't think there will be a stay. I don't think the Ninth Circuit will grant a stay under these circumstances.
John Runft, we appreciate you coming in. This is still very confusing. We're going to definitely need your advice in the coming days. Thank you.